And you would agree with me that situations where physical force is necessary are fluid and dynamic, yes?
Yes.
They're tense,
Often, yes.
uncertain,
Yes.
rapidly evolving.
Sometimes, yes.
And you would agree that it takes time for an officer to perceive something, make a decision, and then take action, yes?
Yes.
Let's talk about the actual investigation of this case. Sergeants Jones and Simons interviewed a number of people, true?
True.
They talked to Officer Kevin Casper, who was involved in the original fight with Mr. Baker at the residence.
Yes.
They talked to Officer Neil Sedgwick, who was also involved in that original fight.
Yes.
They talked to Officer Brandon Kreitz, who was present at the holding cell with Officer Sanders.
Yes.
And Officer Matt Hibler, who was also present at the holding cell.
Yes.
And they talked to Mr. Larson, who was the paramedic who came to the police department to look at Mr. Baker after the incident, yes?
Yes.
They talked to Rob's direct supervisor at the time, which was Sergeant Bruce Houston.
Yes.
And as we know, you talked to Chad Craig, who was the department's use of force instructor, correct?
I did not. The investigators and internal affairs did.
Correct, okay. And also talked to Rob Sanders.
Yes.
Reviewed all the original police reports from that night's contact with Mr. Baker, excuse me.
Yes.
They looked at Rob Sanders' training records.
Yes.
Rob was a longtime firearms instructor with the department,
Yes.
and firearms is use of force, correct?
Correct.
He was a pursuit driving instructor.
Yes.
You looked at general departmental use of force training records.
Yes.
You reviewed a variety of videos from that night.
The investigators did.
Correct. And by you, I'm talking about the Internal Affairs Division
Yes.
generally. Okay. And those included videos not only from the police station itself, but also from a variety of officers' cars, true?
True.
Your investigators had Rob's police report when they interviewed him, yes?
Yes.
And consistent with that report, Rob told them that when he arrived at Mr. Baker's residence, he saw 3 officers bringing Mr. Baker out of the house, yes?
I would have to go back to look at his report. I don't remember the specifics of it, just
Okay.
generalities, really.
Well, do you recall watching some videos of patrol cars that were rolling to the house while the fight was on?
Yes.
And you would agree with me that just the open mic portion of that fight, from the time that the fight is on, as far as the radio knows, to the time that Mr. Baker was in custody, was at least a minute and a half long, wouldn't you?
I believe that's correct.
And you would also agree with me that an all-out fight with a suspect for a law enforcement officer that goes on for at least 90 seconds is a serious fight, isn't it?
Yes, I
As
would
a-
categorize it as a long fight.
That is an extremely long time to fight somebody as a police officer, true?
True.
That requires a highly determined suspect, doesn't it?
That could be one reason,
What are some other reasons?
that they're under the influence of something. That's the second thing that would come to mind for me.
Both of those are pretty dangerous situations, aren't they, for the
Yes.
officers? And for the subject, true?
True.
And that's especially true if that person can take on 2 officers for that long.
Yes.
Now, I was aware that Mr. Baker was still belligerent and he was still uncooperative even after he'd been handcuffed at the scene of the arrest, true?
That is what the reports indicated, yes.
And you were aware that Mr. Baker had been pepper sprayed during the fight at his house?
Yes.
And you're aware that according to the officers, that pepper spray did not seem to have any effect on him at all?
True.
He just kept on fighting, yes?
Yes.
Now, after finally getting control of Mr. Baker,
I'd like to check at this point. What's the logical relevance where you have a fight that is extremely previous to wherever the action is? All he really is doing is slamming the character of Mr. Baker.
no, Mr. Jackson.
Overruled, I like your old story.
Thank you. So consistent with Ralph's report, he told them that he saw 3 officers bring Mr. Baker out of that house, yes?
Again, I don't remember the specifics, but there was more than one.
And then, once they finally got Mr. Baker under control and into a car, he was transported to the police department.
Correct.
where Rob Sanders spent over 4 minutes washing Mr. Baker's face and eyes out with a hose in the garage.
I don't know about the specific time, but I do know that he assisted him with rinsing his eyes out with the hose in the garage.
It was quite a while, wasn't it? You remember watching the video?
It's been a while since I've seen it, and I don't know that I paid close attention to the amount of time.
Have you ever washed somebody's eyes out in the garage?
Possibly, I don't specifically remember doing that, but I know that that's something that we've done through the course of the years.
Is there anything in this pepper mace policy that requires you to do that?
The section, I think it mentions in there water, so it would fall under that, I would say.
Sure, but there's no requirement that an officer, when somebody's been pepper sprayed, takes them to the garage and washes them out with a hose, is there?
No, nothing that specific.
And you know that the treatment for pepper spray is water at first and then time and air, correct?
Correct.
Okay. In fact, after a certain point, the more water you put in, the worse you make it.
I have heard that. Again, I'm not an OC expert, but I know that fresh air is important after you rinse.
Have you ever pepper sprayed somebody in the course of your duties?
I have.
Did any of those people ever keep on fighting?
Yeah, I believe people did through the
Okay.
years.
It is not a magic elixir, is it? It doesn't just immediately end anything.
No,
And somebody can be under the effects of pepper spray, but if they know where you are and they're capable, they can still fight like hell, can't they?
they can still fight, yes.
So let's run through this list Mr. Nose talked with you about earlier. I'm on the pepper spray here. Do you have a copy of it?
I don't.
You have it?
So these 150 you're talking about?
Yes, sir. And this was subsection C, the oleoresin capsicum decontamination procedures in humans.
Yes.
After control has been established and or resistance has ceased, the officer will make reasonable efforts to allow the OC affected subject relief from the discomfort associated with the application of OC. Did you read that right?
Yes.
And severe symptoms are expected to disappear in 45 minutes or less, yes?
Yes.
Okay, with only minor after effects.
Yes.
But as you said, it depends on the person, doesn't it?
Yes.
Let's see. Reasonable OC decontamination efforts may include, as practical under the circumstances of the exposure, removing the affected person from the spray area to an area of fresh air or providing some other form of ventilation. Rob did that, didn't he?
Mr. Baker was removed from the original spray area when he was removed from the house.
Okay, you can also inform the person of the anticipated effects of OC exposure. Did Rob Sanders not do that you know of?
Not that I know of. Again, I don't remember the specifics of the conversations between Mr. Baker and the officers as far as the effects of the pepper spray.
Okay, and blowing one's nose is a way to help remove the OC that may have been stuck to your nasal hairs, right?
Yes.
Because that's what it is. It's kind of a little, called a liquid powder. It gets on the hairs up in your nose and irritates, yes?
Yes.
Okay, so if you blow your nose, you help to clean it out.
Yes.
You can allow the affected person to flush the affected area with saline solution or large amounts of clear water, if available, to
Yes.
relieve the inflammation of the eyes and skin. You're not required to do that, are you?
Required to,
Allow the person to flush the affected area with large amounts of clear water.
this policy says if it's available.
It's available. Okay, and Rob actually did that, didn't he?
Yes.
Okay. If practicable, they should be allowed to wash all exposed skin areas with mild soap and water. The holding cells, at this time, the sinks didn't work, did they?
In that holding cell, it didn't work then. I'm not sure about the others. We had other holding cells that had, they call them sinks, but it was kind of a combination, I believe, of a water fountain sink kind of apparatus. And I'm not sure about the other ones, whether or not those were in working order.
Okay. But you know there were other prisoners down there that night, right?
Not specifically.
Let's see, the last one that was mentioned, arrange for professional medical attention if the person complains of injury or if the officer reasonably believes that the person needs medical attention. Obviously, they're talking about from the effects of the pepper spray, correct?
Since it's under this policy, I would assume that.
Okay. Was there any information developed in the internal affairs investigation that Mr. Baker complained of injury from the pepper spray?
I don't recall that, I don't believe so.
Okay. Allow the affected person to remove contact lenses if applicable and practicable. Do we have any idea if Mr. Baker wore contact lenses?
I have no knowledge of that.
Allow the affected person to remove or wash affected clothing if practicable to do so. You have washing machines in the jail?
We don't have a jail, we actually just have holding cells, but
That's right.
we don't have a washing machine,
It's not a jail, is it? It's just some rooms where you put people for short amount of time.
temporary.
So, Rob does wash his eyes out for several minutes in the garage,
Yes,
and then he takes Mr. Baker to the booking area, yes?
yes,
And as you understand it, Rob was attempting to get some cooperation and build some rapport with Mr. Baker.
I don't recall the specifics of the conversation, no.
Okay. Mr. Baker was intoxicated, yes?
Yes, there were signs that he was intoxicated.
And you're aware that the investigation determined Mr. Baker was calling Rob boss during that time?
Yes,
And boss is a term often used by prison inmates toward guards.
I object, that's completely speculative.
That is speculation. Just-
Well, do you have any basis from which to know if that's true or not?
I have been called that at different times during my career. I've heard that that's where that comes from, but I don't have any direct knowledge of that.
Okay, you've never been a guard in a correctional facility.
I have not.
But if somebody started calling you boss, it would certainly be on your mind that this person may have done real time.
I object, the same thing, it's completely speculative.
She was asked the question if she would do the same thing that Rob did under the same circumstances. I'm
Go
sorry,
ahead, she can answer, go ahead and answer.
do you recall the question?
If you could repeat it, that would help.
If you heard someone start calling you boss, based on what is in your mind, you would suspect that that person may have done time in prison.
I would believe that was a possibility.
Yeah. Okay. And you're also aware that Rob saw what he believed to be prison tattoos on Mr. Baker.
He did say that.
And you have some basis to understand if prison inmates might have some exposure or experience with cell extractions.
I would assume so.
So your investigation determined that Rob eventually put Mr. Baker in the holding cell, and Mr. Baker began pounding on the door, yes?
Yes.
And you know that at the time, it was the policy of the police department that if somebody banged on the door and refused to stop, they'd be handcuffed to the ring in the back of the cell. Isn't that true?
That was not a policy.
Well, it was certainly the practice of the police department, wasn't
I do believe that was common practice.
it? Okay. And the restraint policy says you can use the ring to handcuff somebody to if they're in danger of hurting themselves or someone else or damaging property.
I believe it did, yes.
And it was the expectation in the Columbia Police Department that when somebody was pounding on the door and they wouldn't stop and they wouldn't voluntarily go to the ring, that force would be used, wasn't it?
I believe, expectation, I don't believe is the word that I would use. I believe that that being an option was probably a better way to put it.
It was a routine occurrence, wasn't it?
Yes, I would say so.
You've done it yourself, haven't you?
Yes,
Now, Mr. Baker refused Rob's commands to have a seat by the ring, true?
yes, I believe so.
And Mr. Baker continued to be belligerent, yes?
That's what was said during the investigation, yes.
And Rob Sanders used his verbal judo training before he ever made any physical contact with Mr. Baker, yes?
That's what his report indicated.
What is
yes.
verbal judo?
Verbal judo is a specific training that's been provided to officers in how to talk to people to try to de-escalate a situation as opposed to escalating it. And there are specific terminologies, phrases, and methods that officers are trained in that assist in doing that.
Things like saying, is there anything I can say or do that will cause you to peacefully comply with my demands and have a seat at the back of the cell?
That is one of those things, yes.
And when that person responds with curses and refusals, at that point, you know that force is probably going to be applied. Yes.
Often, yes.
And when Rob did that, Mr. Baker cursed him and remained belligerent. Yes.
Again, that's what the investigation indicated.
And so according to the policy, custom, practice, and training of the Columbia Police Department, Rob was entitled to use force to put Mr. Baker on the ring, yes?
I objected that. It wasn't, certainly not the policy. That's not what was in evidence, and she denied that a minute ago.
Well,
I don't know if she denied that. We were talking about force.
They were
The
talking-
real issue here is
They're
the
talking
degree
about
of
practice.
force.
We're talking about putting somebody in the ring. It was practice to put them on the ring. It wasn't policy to put them on the ring.
Okay. All right.
let me rephrase it.
Okay, for that reason.
So, because it was the custom and practice of the police department to put somebody on the ring and to use force to do it, once Mr. Baker demonstrated that he would not do it voluntarily, under the police department's practice, Rob Sanders was entitled to use force to put him on the ring, yes?
Again, I think the terminology I would use is that that would be considered as an option.
Now, you understood that Rob did not want another lengthy fight, as he believed the 3 officers had tangled Mr. Baker earlier that evening.
Yes, that's what he said.
You understand that Rob actually considered doing a leg sweep.
Are you asking?
Yes, ma'am.
Yes.
But he decided that based on the parameters, the confines, where Mr. Baker was, he didn't think that would be a good move, right?
Yes.
You understood that it was Rob Sanders' intent to knock Mr. Baker over on his bottom so that Rob and the 2 other officers could get in and get him over to the ring.
He said that was his intent.
Do you have any reason not to believe that?
No?
Now, in evaluating the move that Rob did use, which was the push, you consulted with Chad Craig, who is the department's use of force expert, yes?
The internal affairs investigators did, yes.
Yes, ma'am. Yes, ma'am. Again, I'm talking about the division generally. Right. And the reason Sergeant Craig now, at the time, the reason Officer Craig was consulted, because as the person who is tasked with implementing the department's use of force system and tasked with training officers on that system, he would be the most knowledgeable person to consult about whether Rob's actions were within policy, procedure, or practice, yes?
The training specifically.
And whether Rob's actions fell within the training that had been provided.
Yes.
I'm going to ask, are you trying to qualify him, Chad Craig, as an expert?
Well, I'm asking the division what it did and why it did it.
Continue. Go ahead.
Now, ultimately, with the assistance of Sergeant Craig, you determined that Rob's push of Mr. Baker fell within the department's use of force continuum, yes?
Based on all of the circumstances, it wasn't just the interview with Officer.
Right. The totality of the circumstances, including Sergeant Craig's assessment, you concluded that the move came within the use of force policy and the training.
Yes.
And one of the things that Sergeant Craig said was that the outcome of the push was not a reasonably likely outcome under the circumstances. True?
True.
He would not have expected to see Mr. Baker do what Mr. Baker did, right?
Right.
He would have expected Mr. Baker just to go over on his own.
I believe that's what he said, without looking back over the specifics of those statements. I don't remember that specific point.
Okay. But ultimately, the Internal Affairs Division's finding that Rob Sanders used an objectively reasonable amount of force. Isn't that true?
Our recommendation was that it was reasonable.
And part of that finding was that a like officer in like circumstances could reasonably respond in like fashion. True? And just because you might do it different doesn't mean that it's unreasonable, does it?
No.
Now, the investigation also determined that there was no policy which required officers to themselves give first aid to an injured person. Isn't that true?
Yes.
And there was no policy that required officers to directly observe an injured prisoner in a holding cell. True?
I don't believe so at that time.
Lieutenant, let me show you what I just marked as Exhibit C. Do you recognize that?
I do.
What is it?
It is a memo that I wrote to the chief in October of 2011,
What's the date on that?
October 13th of 2011.
You prepared it?
Yes,
In fact, those are your initials up on the, next to the line that says it's from the Internal Affairs Division.
yes,
Did you prepare that in the normal course of business for the Columbia Police Department?
yes,
Did you prepare it at or around the time of the events that you were talking about
in October, yes.
And I will move to admit that as Exhibit C.
Any objection?
I don't know if relevant is or not.
I don't think you actually moved as Exhibit B yet. You provided us copies, I know that.
That's the IA report. Yeah, it's fairly substantial. I don't have copies for everyone. What I think we'll do is when I get a chance,
Do
we'll
you have
take
an
them.
objection to Exhibit B?
Can we get a copy made so everybody can see it? I don't have to object.
You have no objection? Yeah, we'd like copies. Anything you're giving to a witness, you're going to make it an exhibit, we want copies.
Give me a copy of the IA report.
Yeah, I don't know.
Would you like me to have those copies made?
If you wouldn't mind. It's probably the hardest one.
Oh, you're still using the other? Actually, just, 6 one.
Could you read that memo, please?
Yes. During 2 recent internal affairs investigations, the issues of rendering basic first aid and observation of injured arrestees/detainees by officers until the arrival of medical help were addressed. The investigations revealed that officers do not receive any ongoing/continuing medical training, and there is currently no policy that explicitly requires officers to render first aid or to visually observe a prisoner with potentially life-threatening injuries until medical personnel arrive. In fact, most officers do not receive any medical training beyond the first responder training that is/was provided in their basic law enforcement academy training. Depending on the length of service of the officer, for some of them it could be more than a decade since they have had medical training. It is the recommendation of the Internal Affairs Unit for these expectations to be added to the department policy and for Training and Recruitment Unit to explore the feasibility of offering periodic basic medical training to officers.
And so having written that memo, you know that there was in fact no policy which required an officer to personally render first aid, true?
True.
And there was no policy that required an officer to physically stay with any injured prisoner and physically watch them, true?
As I said before, I don't believe that at that time it was.
There is now, isn't there?
Yes, I believe so.
After everything was Rob Sanders, right?
I don't remember the date that that went into effect, but I believe it was after.
Now, Internal Affairs determined that Rob Sanders actually complied with the use of force policy as far as rendering medical attention, true?
Sure.
Do you still have that policy handy up there?
No, the only one I have here is covering this.
Well, Section 8 of the city's Exhibit 22, it's actually Section 3, Roman numeral 3, Section 8, says medical attention. 8.1, injury. Officers should make appropriate medical aid available to any person who is injured, who lost consciousness, or who claims to have been injured as a result of the actions of an officer, or who has ingested some item that could be presumed to have or could cause injury. 8.3, uses of force. Officers should summon emergency medical personnel for any person upon whom one of the following was used: a conducted energy device, deadly force, vascular neck restraint, impact weapon, less lethal device, or department hands. Now, the investigation of Rob Sanders had to do with Section 8.1, right? Injury?
If I can see it
You
again.
certainly may.
Yes,
Because he didn't do any of the things in Section 8.3. He didn't tase him or shoot him or
I
anything
object to
like that.
that characterization. Less than lethal is pepper spray.
He didn't pepper spray.
He was fighting from the effects of pepper
He didn't pepper spray, but somebody had.
spray. Right, somebody had.
So what's your objection again?
That he's characterizing that pepper spray isn't covered at all, when I believe it is covered in.
We have a policy on pepper spray,
Yeah.
so it is covered.
Well, here's the question, Lieutenant. Internal Affairs determined that Rob Sanders complied with that policy, didn't he?
I object to Internal Affairs that determined that. Internal Affairs' ultimate recommendation was something different than that. It was unfounded.
Well, you guys need to clear this up for the board here, I think, because at one time, we got two different stories. Right now, we're saying that they set aside some of these claims, and early on, we've got this internal memo that says they were sustained. So I'm confused.
Well, exactly. And I will come around to that.
Okay, go ahead.
And so, in order to make a recommendation, you have to make a determination, don't you?
yes,
You have to draw a conclusion whether an officer has or has not violated the policy.
yes,
And your conclusion as the IA department, the IA division, your conclusion was that Rob Sanders fully complied with that medical attention policy.
yes,
Now, we looked at some notifications of findings earlier, and we talked about the amended notifications where we added we went from a mandatory review to a charge of essentially excessive force, right?
yes,
Okay. And it was Chief Burton who required the amended notification. He basically made the complaint of excessive force, right?
yes,
And then the medical attention was added as well, right?
yes,
And that was also at the direction of Chief Burton, yes?
yes.
Okay. And let's take a look at this city's Exhibit 23, which is the notification of findings. And as Mr. Chairman just mentioned, those all say sustained, right?
Yes,
That means he's found guilty of violating those provisions. Yes?
yes,
And we've talked about the Internal Affairs report, which the board can find at page 98 of the Black Book, which is the very last part of it, the recommendation. And on those, it says unfounded, right?
yes.
And what does unfounded mean?
The way that we had used it up to that point was that the allegation as alleged did not occur.
So when you say in the recommendation that the allegation of a violation the department's code of conduct policy, duty to use reasonable force be considered unfounded, what you're saying is Rob Sanders didn't violate that policy.
Correct.
And whether you semantically call that exonerated or proper or anything, the point is, the conclusion of IA is Rob Sanders did not violate the policy, right?
That was our recommendation, correct.
And that was your recommendation on the medical attention provision under the use of force policy, yes?
Yes,
Okay. And you did not develop any information in this investigation to suggest that Rob Sanders somehow violated the pepper spray policy, true?
true.
And then finally, it is further the recommendation of the Internal Affairs Unit that the allegation of a violation of the City of Columbia's guidelines for corrective action be considered unfounded. So what you're saying there is, because he didn't violate the force policy, and because he didn't violate the medical attention policy, you can't ring him up on the one that ties it all together, right?
In your wording.
Okay.
That's not how I would word it, but
Well,
essentially.
word
I
it for me.
accepted that characterization.
Yeah, let her work.
Go ahead and word it.
I would say that we recommended that allegation be unfounded, as we did not believe a violation of that had occurred.
Right. But those violations are premised on force and medical attention.
I object to that, absolutely. There are 3 separate charges. They know there are 3 separate charges, and he's trying to mischaracterize the evidence that's already been in the record and accuse the board.
Well, let's look
I
at,
sustain that, because I'd really like you kind of go through these one at a time.
okay, let's find,
And further clear up for us the distinction between this internal force or sustained and what we're talking about now, which seems to be just the opposite.
I think temporally, I think we need to deal with IA first, and then let me come around to why the notification is different.
We're going to get there sometime.
We will, absolutely. Okay. Let me find the right one. Okay. Section 19-225, guidelines for corrective action. This is page 63 of the Black Book. The seriousness of an offense will often vary with the circumstances prevailing at the time it occurred and the motives which prompted it. All factors must be considered when determining the appropriate action to take in a particular situation. The violations set forth in this provision may be considered as just cause for suspension or discharge. The list of offenses presented here does not purport to be all-inclusive. Neither is it intended that these guidelines should be rigidly followed. Now, what we've talked about in this case falls under subsection 3, abusive or improper treatment of a client, prisoner, citizen, or other individual in the community or on the city payroll.
Okay, is there a question here? We're discussing back and forth what that says legally.
Well,
Reading, so it's fine, it's in policy. Go ahead.
Lieutenant, let me ask you this. Other than excessive force and medical attention, were there any allegations made about Rob Sanders abusing or improperly treating Mr. Baker?
No, there were no other allegations.
So,
I object to that characterization. It is an allegation. That is how Chapter 19 works. It is a separate allegation. Scott doesn't want it to be,
It is-
because it hurts his case.
it is